Hi, I'm Janice Switlo, and this will be part 2 in further information regarding the J Treaty. Today I want to speak about the Mitchell case, because again, everyone seems to think, oh, this has already been decided, there's nothing we can do, there was already a Supreme Court of Canada decision on it. Let me describe exactly what that decision is, what it is and is not. First of all, it's important to remember this was an individual involved, okay, Grand Chief Michael Mitchell. Just because he holds that title does not mean he was there in capacity of representing any nations. He was not. He was there in his own individual capacity. The interveners were all Canadian entities. The Mohawk Council of Kanawaki, the Assembly of First Nations, and the Union of New Brunswick Indians. These are not Indigenous nations representatives. And here's how the individual is described. Here's how he's presented. Here is how he is coming into court and saying who he is. And remember, this is repeated, so this is a representation that, without my seeing the actual pleadings, I can't say for sure. But when judges are quoting something the same, usually it means it's been written by someone, and usually it's the lawyer for the person. The respondent is a Mohawk of Akwesasne. Pardon me, I'm really sorry. I read mostly. Pronunciation's really one of my weaknesses. He's a Mohawk of that community and a descendant of the Mohawk Nation. One of the polities of the Iroquois Confederacy prior to the arrival of Europeans. So, right off the bat, he's in this community. There's no longer a Mohawk Nation because that died with the arrival of Europeans. It says who and how, right? And remember, this case is from 2001. This is not that long ago. So just the background on what happened. In 1988, the respondent, Mitchell, crossed the international border bearing goods purchased in the United States. He declared the goods to Canadian customs agents, but asserted that Aboriginal treaty rights exempted him from paying duties. This is a Section 35 doctrine case. It's really important to remember that. And it's based on the fact that he's just a descendant of what was a nation, but not anymore. Now he's a domestic ethnic minority. He was permitted to continue into Canada, but advised he'd be charged duty, etc. So again, the appeal should be allowed. The claimed Aboriginal right has not been established. Okay, it says, so again, this is a Section 35 case. And this sets out, what I'm reading to you is going to really emphasize for you just how horrible this Section 35 doctrine is. So the justices say, the Supreme Court of Canada, under English colonial law, this is not Indigenous law. And let's be clear. The law of the land is trite to say it's where the land is. That means that the actual jurisdiction of the land is Indigenous law. This case says under English colonial law, the pre-existing laws and interests of Aboriginal societies were absorbed into the common law as rights upon the Crown's assertion of sovereignty, unless these rights were surrendered, extinguished, or inconsistent with Crown sovereignty. Just because common law says so. The enactment of Section 35 of the Constitution Act 1982 accorded constitutional status to existing Aboriginal treaty rights, including the Aboriginal rights recognized at common law. These are not recognizing Indigenous law. However, the government retained the jurisdiction to limit Aboriginal rights for justifiable reasons in the pursuit of substantial and compelling public objectives. The test to establish an Aboriginal right focuses on the integral defining features of the relevant Aboriginal society before the Crown's assertion of sovereignty. So the judges went on to say that the evidence does not establish the northerly trade as a defining feature of the Mohawk culture. And even if the trial judge's generous interpretation of the evidence were accepted, it discloses negligible transportation and trade of goods by the Mohawks north of the St. Lawrence River prior to contact. This trade was not vital to the Mohawks' collective identity. It follows that no original right to bring goods across the border for the purposes of trade has been established. Now, what I speak about is continuing economic sovereignty, because it's not been handed over by treaty, but it is, of course, under attack, and the effort is to have you sign off that you don't have it. Economic sovereignty, as I said, has not been given up, and it's not limited to what you did before the Crown asserted sovereignty. Now let's look at this core element of the Section 35 doctrine. Again, remember how it was put in place. Go back to the episode regarding the Section 35 briefing that I actually read and provided to Anishinaabe. Compare that, and I've spoken about the duty of fairness. How can Her Majesty, the Crown, bear assertion of sovereignty when previously and during that same period of time she entered into treaties? Remember that important duty of fairness. She did treaties. She did not declare war. There has been no conquering. So how is it possible to say, oh, this made up thing, oh, she just asserted sovereignty, that's how we're going to work this doctrine? That's really not good law. It's ridiculous. And to free, they say, oh, it's not a frozen right, can't freeze it. Well, what else would you call it when it's based on what they were doing back then? Economic sovereignty means that you can pursue all manner of trade and commerce. And remember, there were treaties that were done whereby the Indigenous parties agreed to limit this is not up in Canada, but south of the border, where they agreed to limit their trade and commerce to only domestic and only with the United States, for example. None of that. There's been no limitation in Canada in terms of the treaties that exist. So it says in this case, an issue arises about the sovereignty implications of the international trading and mobility right claimed by the respondent as a citizen of the Iroquois Confederacy. So they're talking about how, what was the foundation? Why was this happening? Well, anything dealing with international rights is not justiciable in a Canadian court. So contrasting with what is true, and that is economic sovereignty, an Aboriginal right under that doctrine must be derived from pre-contact activity that was an element of a practice, custom, or tradition integral to the Aboriginal community's distinctive culture. Now this is key. Counsel for the respondent, that's Mitchell, does not dispute Canadian sovereignty. He seeks Mohawk autonomy within the broader framework of Canadian sovereignty. He says, I willingly put myself under Canada, and I have proceeded to defend myself on the basis of the Section 35 doctrine. This is all within the control of Mitchell, although whether he realized he was doing that or not, who knows, right? It's his lawyer in court, not him. The respondent's claim is not just about physical movement of people or goods in and about Akwesasne. It is about the Mohawks' aspiration to live as if the international border boundary did not exist. Well, you can't argue that if you're conceding you're under Canada, because once you concede you're under Canada, obviously those borders apply to you. You're a domestic ethnic minority, and you've been deemed a citizen back in 1960. So, of course, you're constrained by that. And it says, whether historically the Crown may have been portrayed as an entity across the seas with which Aboriginal people could scarcely be expected to identify, this was no longer the case in 1982, when the Section 35 reconciliation process was established. The Constitution was patriated, and all aspects of our sovereignty became firmly located within our borders. If the principle of merged sovereignty articulated by the Royal Commission on Aboriginal Peoples is to have any true meaning, it must include at least the idea that Aboriginal and non-Aboriginal Canadians together form a sovereign entity with a measure of common purpose and united effort. I say to you that the people I've talked to across this part of the world have never said anything like that. Okay, they say I'm still of this nation. We have a nation-to-nation relationship. We didn't merge. Show me the document, right? Show me the treaty. Where did we do that? Certainly none of the existing treaties have done that. It is this new entity, as inheritor of the historical attributes of sovereignty, with which existing Aboriginal treaty rights must be reconciled. The constitutional objective is reconciliation, not mutual isolation. What is significant is that the Royal Commission itself sees Aboriginal peoples as full participants with non-Aboriginal peoples in a shared Canadian sovereignty. Aboriginal peoples do not stand in opposition to, nor are they subjugated by Canadian sovereignty. They are part of it. So in 2001, the Supreme Court of Canada, a strong paper trail saying, hey, you've always been under Canada. You agree with this. As of 1982, this is what happened. And somehow, this shared sovereignty, which, I've spoken about shared sovereignty in the past, but it's under this context. You have Indigenous nations having whole sovereignty, granting permissions to the Crown to exercise partial political sovereignty. There's nothing about selling land. There's nothing about giving up economic sovereignty. And so technically, you can describe the realities of it, not this, what's created by the Supreme Court of Canada to facilitate a desired end result. Yes, that's sharing, right? The respondent's claim, Mitchell, presents two defining elements. He asserts a trading and mobility right across the international boundary, and he attaches this right to his current citizenship, not of Canada, but of the Iroquois Confederacy. Now, British colonial law, the courts continue, presumed that the Crown intended to respect Aboriginal rights that were neither unconscionable nor incompatible with the Crown's sovereignty. Courts have extended this recognition to practices, customs, or traditions integral to the Aboriginal community's distinctive culture. While care must be taken not to carry forward doctrines of British colonial law into the interpretation of Section 35 without careful reflection, Section 35 was not a wholesale repudiation of the common law. What this is saying is, we did not repudiate the doctrine of discovery. It remains there, and these notions have carried in. It's building upon that same rotten foundation that needs to be replaced. This is the doctrine of discovery brought forward to modern times. So the courts continue, this concept of sovereign incompatibility continues to be an element in the Section 35 analysis, albeit a limitation that will be sparingly applied. For the most part, the protection of practices, traditions, and customs that are distinctive to Aboriginal cultures in Canada does not raise legitimate sovereignty issues at the definitional stage. So it continues, and I'm sorry that there are two more paragraphs here and then I'm done quoting from this. With the creation of the international boundary in 1783, Akwesasne became the point at which British and later Canadian sovereignty came face to face with the sovereignty of the U.S. Control over the mobility of persons and goods across a border has always been a fundamental attribute and incident of sovereignty. States are expected to exercise their authority over borders in the public interest. The duty cannot be abdicated to the vagaries of an earlier regime whose sovereignty has been eclipsed. Dead, gone, darkened. Therefore, the international trading mobility right claimed by the respondent is incompatible with the historical attributes of Canadian sovereignty. Since the claimed Aboriginal right did not survive the transition to non-Mohawk sovereignty, there is nothing in existence in 1982 to which Section 35, protection of existing Aboriginal rights, could attach. Listen to those words, what they're saying. right? Just because the Crown declared and asserted sovereignty. That's absolutely inconsistent with her duty of fairness and what she did elsewhere in all the treaty making. This is why I call Canada an outlaw nation, because it's not a constitutional progression. And to acknowledge and be building upon the doctrine of discovery, again, not good law. So then it can this conclusion is not at odds with the purpose of Section 35 to bring about a reconciliation of the interests of Aboriginal peoples with Canadian sovereignty. Aboriginal people are part of Canadian sovereignty, and the accommodation of their rights is not a zero-sum relationship between minority rights and citizenship. So again, defining you as a domestic ethnic minority because there was a historical connection. You were beasts of the field. You stayed there. In 1982, that was formalized as you being merged into and somehow came under Canada. All of this, by the way, you look at international law, this is not how things are done, okay? So affirmation of the sovereign interest of Canadians as a whole, including Aboriginal peoples, should not in this case be seen as a loss of legitimate constitutional space for Aboriginal peoples. To extend constitutional protection to the respondent's claim would overshoot the purposes of Section 35. In terms of sovereign incompatibility, the respondent's claim relates to national interests that all of us have in common, rather than to distinctive interests that for some purposes differentiate an Aboriginal community. Reconciliation of these interests in this particular case favors an affirmation of our collective sovereignty. This conclusion neither forecloses nor endorses any position on the compatibility or incompatibility of internal self-governing institutions of First Nations with Crown sovereignty, either past or present. I think there might actually be one other thing I might have wanted to highlight. Just a minute for me. Yes. Be very clear again what was being asked, what was brought into the court, what is justiciable. Grand Chief Michael Mitchell claims that his people have an Aboriginal right that ousts Canadian customs law. The government replies that no such right exists. First, because the evidence does not support it, and second, because such a right would be fundamentally contrary to Canadian sovereignty. And at the heart of this case is whether the evidence establishes an Aboriginal right, again, as described and defined by the Section 35 doctrine. And again, this is where I said it's repeated. Chief Mitchell is a Mohawk of Akwesasne, a Mohawk community located just west of Montreal and a descendant of the Mohawk Nation, one of the polities comprising the Iroquois Confederacy prior to the arrival of Europeans. So can one person go into court with a lawyer and have interveners from Canadian entities, AFN for instance, and say, there is no Mohawk Nation, I'm just a member of this community, I accept I'm under Canadian, we're all under Canadian Constitution now because of 1982, that somehow, some way, some miraculous way, just because the Crown asserts it, and just because a hand-picked pal of a prime minister put in place the Section 35 doctrine makes it so. I say it does not. I say this is, again, I'm repeating myself ad nauseum. This is bad law. The basis upon which these decisions have been made, people are much more well informed. They know these nations exist. I've seen it, now I understand completely why elders and teachers in Longhouse, for instance, wanted me to witness, the importance of witnessing. I'm not just reading this, I'm not just hearing from someone speaking it. These nations, their economic trade and commerce, their sovereignty, all functioning still, albeit severely oppressed, severely interfered with, there's no question. But in my humble opinion, and I've spent over 30 years looking at this and witnessing, the Indigenous nations remain alive and well, and they can no longer be dealt with in such racist manners. We can't just take what they own. You need to respect, Canadian governments need to respect what the limits of their permissions granted by these incredible nations that have existed for thousands of years, need to respect those deals. That's all I have to say.